Essential step number 1, open the probate. Sounds simple. Opening the probate, what is involved with that? So first of all, you need to figure out who is going to be the personal representative of the estate. Who is going to have that legal authority? The personal representative of the estate will be the person who is nominated in the will. So the will should say that so-and-so will serve as personal representative. What happens if there is not a will? Well, then we'll get into that, but there will still be somebody who is a personal representative. It's just that that person has not been nominated by a will because there isn't a will. So usually a probate is opened within about 30 to 60 days of a person's death. Lots of times families contact us right when somebody has died, and I tell them, please take the time to go through the grieving process. That's the most important thing for you right now. None of the business of the estate has to be handled immediately, but oftentimes people do want to, have some guidance. What should they do? So for a do-it-yourself probate, take a little bit of time to make sure that you've dealt with the loss, the grieving process, and then if you're the person who's been nominated by the will, or if not, there's no will and you're a family member, what do you need to do next? What you need to do next is open the probate in the court. Well, how do you open the probate in the court? There are legal pleadings that are required. There is a petition to admit the will or a petition to start the probate if there is no will. If you're the personal representative nominated or you want to serve in that capacity because there's nobody else nominated, you need to prepare an oath. There is an oath where you swear, you write down that you will do your job, because being a personal representative is a job. It might be considered an honor, but more than anything, it's a job, and it's a job you have to do if you're going to accept that position. So what happens is you fill out the petition, you fill out the oath, you prepare an order, you take it to the court, there's a filing fee of $240 to start the probate. You take the original will and you have the judge then sign an order that says, yes, this probate can start because this is the original will, this is the person who's nominated, they've done an oath, and here is the order signed by the judge. Now, once you have opened this probate, the next step that you do is you want to get what's called letters testamentary. So with the order, you go to the clerk's office and you get letters testamentary. That is your legal authority to conduct business on the part of the estate. So you've probably heard that term before. Letters testamentary are critically important to administer the estate. That's your authority. If there isn't a will, they're not called letters testamentary, they're called letters of administration. But they have the same authority, which is you have the authority to do whatever has to be done on behalf of the estate. Kind of think of the letters testamentary sort of like if you had a durable power of attorney for somebody while they were alive and you had the legal authority to act on their behalf while they are alive. Letters testamentary are like that, but for a decedent. One of the things that people are often surprised about, I just wanted to mention, is that when somebody has died, the durable power of attorney document dies with them. So there is no longer any legal authority for the attorney, in fact, the person who's been designated as that power of attorney. Instead, to get the authority, open the probate, file these pleadings with the court, get the letters testamentary, and then you have the legal authority to conduct business on behalf of the estate. All right, so that's step number 1. This is a good question, and I think I'll answer it now is, do you have to open a probate? No, I mean, there's no requirement that anybody have to open a probate. So a couple of things. Sometimes no probate is necessary. Lots of times when we set up estate plans for people, we do it so that there won't be a probate, either through the estate planning documents we did, or sometimes it's because a revocable living trust exists. There's a lot of reasons that there may not need to be a probate. Perhaps the estate is small, it has under 100,000, then all is needed is a small estate affidavit. There's a lot of reasons why probate is unnecessary. And so that's one of the first things you're going to want to find out is, before you do the filing fee and pay the $240 to open up the probate in the county where the decedent resided, do you need a probate? So that's a really good question to answer first before you go through all of that work. Let's say a probate is necessary. Do you have to serve as a personal representative just because you're nominated? No, you don't. If you choose not to, then the next person who's nominated would have the right to step up. Let's say there's no will, there's nobody nominated, but you're the family member. Do you have to serve? No, you never have to serve as a personal representative. But usually there's a reason people do want to serve. They want to wrap up the business of the decedent, or there's assets to distribute. So that is definitely a motivating factor, is the assets of the decedent aren't going to go anywhere unless somebody does this work if it needs to be done. Sometimes estates are just debts, no assets. And in that event, you let the creditor do the work of probating the estate because they're the only one that's going to get anything. So kind of a long-winded answer to, do you have to open up a probate? I would say it depends. Do you have to serve as the personal representative? No, only if you want to and there's a good reason for you to do so. So that was step number one, opening up the probate.